The U.S. Supreme Court has a number of critical Voting Rights Act cases, and they may be getting another blockbuster one. Welcome back to Democracy Docket. I'm Marc, Elias.
And I'm Paige Moskowitz. Let's get started.
All right, Paige, one of the really wonky issues you and I have covered and the pages of Democracy Docket cover regularly is the so-called private right of action under the Voting Rights Act. This is the allowance for private parties to bring claims that says that the Voting Rights Act has been violated. The Republican Party, from top to bottom, from its most moderate wing to its most conservative, has been trying to do away with these kinds of actions. They want to say that the only one who can bring a lawsuit to vindicate the rights of voters under the Voting Rights Act is Pam Bondi and the Department of Justice. This would be a calamity for democracy, but they have been chipping away at this in circuit after circuit. It is not yet spread nationwide. It is not yet even spread so far to the circuits with the most Voting Rights Act cases. But a big development out of North Dakota, of all places, may tee up the Supreme Court to issue a ruling, or at least hear a case, that could decide this issue nationwide.
Right. In North Dakota, the Turtle Mountain Band of Chippewa Indians, the Spirit Lake Tribe, and Native American voters filed a lawsuit challenging the state legislative map, saying that it violated Section 2 of the Voting Rights Act. It harmed Native American voters. It did not give them full and equal voting power that they should have. A district court judge agreed that the map violated Section 2 of the VRA. State officials appealed it up to the Eighth Circuit, arguing that there is no private right of action, as you described, Marc. The Eighth Circuit agreed. Now the plaintiffs are planning to ask the U.S. Supreme Court to review the issue, which could change the status quo of voting rights litigation nationwide.
Yeah, and this is big roll of the dice. This is big stakes decision by the plaintiffs here, because the Eighth Circuit right now has ruled against this. But the Eighth Circuit covers North Dakota, South Dakota, Nebraska, Minnesota, Iowa, Missouri, and Arkansas. Now, I don't want to minimize the lack of private right of action in those states. It's a tragedy for voters in those states, including for the Native American plaintiffs in this case. So I'm not at all being critical of them. I will just say, as a matter of fact and observation, the most use of the Voting Rights Act, private right of action, is actually in the Deep South. It's in the 11th Circuit and the 5th Circuit, right? What are we talking? We're talking Georgia, Florida, Alabama, Mississippi, Louisiana, Texas, right? Those are the states where you just see, to some extent, Arizona in the 9th Circuit, right? It's just where you tend to see more of the racial discrimination claims under the Voting Rights Section 2 brought for obvious reasons. And so far, there is still a private right of action in those circuits. Now, look, it's being challenged everywhere. You know, everyone, my favorite Republican vote suppressor, Brad Raffensperger, who unfortunately too many people that treated that fraud as some kind of voting hero, he's actually saying there's no private right of action, trying to get the 11th Circuit, which covers Georgia, to say that there's no private right of action. So this is a Republican, priority all around the map. But obviously, the decision to bring this to the Supreme Court, where it is only affecting one circuit, is a big, like I said, big move. And we don't know that the Supreme Court will take the case, but if they do, this is going to be high risk, high reward. If the Supreme Court, as they should, says there is a private right of action, and let me be clear, the plaintiffs are right in the Eighth Circuit case, they are 100% right. Of course, there's a private right of action. There has always been a private right of action since the beginning of the Voting Rights Act in 1965. Private plaintiffs have been bringing claims, and so the Eighth Circuit is entirely wrong here. And if the Supreme Court were to take this case and say that, that would restore this and settle this question and be a big win for democracy. On the other hand, were the Supreme Court to go the wrong way, go sideways on this, and say no private right of action under Section 2, it is potentially a devastating outcome, because then we are at the hands of Pam Bondi to be the only one who can pull the trigger on a Voting Rights Act case, at least until the end of Donald Trump's term.
Marc, we have seen for the past few months how the Trump administration has completely gutted the mission of the voting rights section of the DOJ to turn it from a pro-voting rights group of lawyers, people who are defending ballot access, to a group that is filing lawsuits, filing briefs, kind of actively attacking the right to vote in states across the country. In fact, Democracy Docket just published a timeline outlining some of the most atrocious steps that the DOJ has taken to attack voting rights. You can read more about it at the link above or in the description below. Marc, I want to kind of get to the meat of what the issue is here. You have said that private plaintiffs have litigated under the Voting Rights Act under Section 2 since it was enacted in 1965. What is the Republican argument here for why now, decades later, suddenly voters, voting rights groups, civil rights groups are no longer able to do that?
Because they think they have the votes on the Supreme Court. I mean, let's just call that out for what it is. I mean, first of all, let's call out the Department of Justice for what it is. It is not just now not protecting voting rights. It's not just now engaged in voter suppression and anti-voting behavior. It's actually acting as an arm of the Trump administration and the Republican National Committee. I'll say it. Okay, just like that's what it is. I mean, Paige, you and I did a video recently about Texas, in which the Department of Justice sends a letter after the White House and the political types in Washington, D.C. say they want Texas to redistrict. Apparently, maybe there was a little bit of hesitation in Texas for whatever reason. They wanted the cover of the Department of Justice. So the Department of Justice sent a letter saying, you got to redistrict. So, we have to understand that this Department of Justice is not what you all are thinking. Even as bad as the Bush Department of Justice might have been, it's nothing like that. There will be nothing left to enforcement of Section 2 for minority voting rights if there is no private right of action. If private plaintiffs, if the NAACP, if LULAC, if organizations like I oftentimes represent in court are not able to bring claims under Section 2 of the Voting Rights Act, that will involve all the redistricting wins in places like Alabama and Louisiana. It'll also redistricting wins in states like Georgia that are still pending in the federal courts. It will have implications in Texas as Texas goes about redistricting. So this is a very, very important issue. And it is a very, very big decision to bring this to the U.S. Supreme Court. But like I said, I don't say that condemning the decision or questioning the decision. The fact is the plaintiffs here have been wronged. The plaintiffs here have been denied their rights under the federal law. And so I understand the decision, but it also bears repeating. This is a very high stakes decision, particularly out of the Eighth Circuit, where if the Supreme Court takes this case, which they may not. I mean, the Supreme Court doesn't take a lot of cases. They've got a bunch of other cases, so maybe they don't take this one. But if they do, all eyes will be on the Supreme Court when that case comes up.
Marc, but we do know of one Section 2 VRA case that the U.S. Supreme Court is reviewing, and that is about Louisiana's congressional map. They heard oral argument on the map last term. They actually didn't issue a decision this past June on the map. They decided to punt it to the next term. So we know for sure that at least in one case, the U.S. Supreme Court will be reviewing Section 2 of the Voting Rights Act. Democracy Docket has followed this case from the beginning. So if you want to stay updated on both the Louisiana case and this North Dakota case, be sure to subscribe to our free daily and weekly newsletters. You can do that at the link above or in the description below.
Yeah, and it's interesting because that Louisiana case is actually a racial gerrymandering case, right? We have turned it back into a Voting Rights Act case. Actually, the plaintiffs won the Voting Rights Act case there, but it's another example of where after a victory, you saw Republicans come in, get a bunch of white plaintiffs say it's now a racial gerrymander. So now you're quite right. The Voting Rights Act is now back before the Supreme Court, even though you would think
in a racial gerrymandering case, which, Marc, to be clear to everyone, those are two separate laws. They're two separate laws.
And, only 2 years after the Supreme Court upheld Section 2 of the Voting Rights Act out of an Alabama case. So there's a lot of this going back and forth in the courts. This private right of action has always been sort of lurking in the background as the Republican sort of wish list, right? It's the thermonuclear bomb that they want to go off, but they have doubted they'd be able to pull it off. And they pressed this issue in a number of places. They've not gotten success outside of the Eighth Circuit. Although, like I said, it bears mentioning the state of Georgia and Brad Raffensperger are still trying to get the 11th Circuit, which covers Georgia, Florida. They're trying to get it to bite there. And the whole team at Democracy Docket are waiting on a decision from the 11th Circuit on that issue. We'll see whether that decision gets sort of held up, informally held up while the Supreme Court sorts all the rest of this out. But this is a very, very important issue. And Paige, it's not just private right of actions that are important for the Voting Rights Act. I mean, that's how it postures here. But there are a lot of areas of the law, and voting law in particular, where we have at Democracy Docket covered, you and I have done videos about the attacks on private right of actions, across a number of laws.
Right, Marc, like everything we talk about, the issue at stake here isn't just this map in North Dakota. It isn't just private right of action under the 8th Circuit. It's not even just about Section 2 of the VRA nationwide. How the Supreme Court rules in this case can affect a whole slew of other issues, like you said, other voting laws, but also non-voting related things. And we have seen how Republicans will often test out outrageous legal theories in the voting domain, see how successful they are there before applying it to other areas of government, executive power, business, etc. So you need to care, you need to worry, not just because you care about voting rights and democracy, but because you care about stability of the rule of law and basically every other facet of life.
Right. And while we're talking about stability and the rule of law, we have some instability coming here at Democracy Docket that I want to tell you about. Paige and I have been doing this series now for years. Before we were doing a YouTube series, we did Twitter Spaces. For those of you who remember our Twitter Spaces, thank you for following us from Twitter to YouTube. These videos are obviously, hopefully much better and more informative. But Paige and I have been sort of working together at this, keeping you informed. But a bit of news, Paige has decided to go to law school. And so this will be Paige's last video, at least for now. Maybe we'll be able to cajole her out of Democracy Docket retirement. At some point, maybe when we have the right topic, she'll come and guest appear. But this will be her last regularly scheduled video. And I know I speak for not just the entire Democracy Docket team, but the entire Democracy Docket audience, all of you, in wishing Paige good luck in law school and in her bright legal career in the future. So she will be tracking, undoubtedly, private rights of action, redistricting, the Voting Rights Act, and a whole bunch of other laws that are not nearly as interesting in the next 3 years. So Paige, thank you for everything you've done for Democracy Docket, for me personally, and for the audience. And we are all cheering you on. Thanks. We'll see you next time.